I'm going to now ask you, Detective, some questions about someone with the initial CL. Do you know who I'm talking about when I say CL?
Yes, I do.
Who is CL in relation to the defendant?
CL is an associate of the defendant. She cleaned houses for the defendant's business, as well as her personal home at times.
Does CL have a criminal drug history?
Yes. CL was not made any specific promises, but at the outset of our interviews, we explained to her that her cooperation in our investigation would result in us working with the prosecutors that were responsible for the charges she was facing. Yes. We told her in our interview that any information that she may have, we would need to corroborate in order for it to be of value to us.
Did you get the impression that part of the reason CL cooperated is because she felt bad for her victim?
Yes, in fact, she so many times in our interviews.
The fact that the witness, CL, has a history of such offenses is important to both the prosecution and the defense for different reasons. The prosecution can allege CL is the link between the defendant and the substance that killed the victim. The defense can say CL's history makes her an unreliable witness. Prosecutors will want investigators to show some things. They'll want to see that there were no inducements, that the testimony to be provided is not tainted. Investigators have to convince a reluctant witness without crossing the line into inducement. It's not as easy as it sounds. Investigators will want to gather corroborating evidence in any case, and it's especially important when dealing with a witness who is less than ideal and or has something to gain or lose.
In our interviews, CL told us that in early 2022, the defendant reached out to her either by phone call or text message requesting that she procure fentanyl for what the defendant reported was a investor who had a back injury. CL told us that she reached out to an acquaintance of hers, acquaintance one, and requested that she introduce her to somebody that could sell her fentanyl.
Using phone records through the course of your interview with CL, were you ultimately able to narrow down on what that date was in February that CL purchased fentanyl from acquaintance 2 at the Maverick and Draper?
Yes, based on forensic evidence, we were able to determine that that date was February 11th, 2022. CL told us that after purchasing the pills from acquaintance 2, she returned home to her house in Heber. She said that either later that night or the next day, the defendant met her in the driveway of that home and did a hand-to-hand exchange of pills for cash.
Does acquaintance 1 corroborate CL's testimony?
Yes. She stated that CL contacted her in early 2022 and asked for someone that could sell her fentanyl. In the body cam, she also retrieves her cell phone and shows investigators the messages that corroborated that.
And what kind of messages were they?
They were messages between acquaintance 1 and CL on Facebook Messenger app.
If CL is incorrect or lying, then why would acquaintance 1 get in on it? What's there to gain for acquaintance 1? There's an acquaintance 2, the person who actually made the sale to CL.
Have investigators interviewed acquaintance 2?
Yes.
Have you reviewed body camera audio and video of that interview?
Yes, I have.
Is acquaintance 2 able to corroborate CL's testimony?
Yes, acquaintance 2 was able to recall that he sold fentanyl pills to a friend of acquaintance 1's in early 2022. The cell records from the defendant's phone show several phone calls back and forth between her and CL in early 2022.
Do they show any text messages back and forth between the defendant and CL?
Yes, several.
Have you reviewed those text messages?
We were only able to see the timestamps and who the sender and receiver was. We're not able to see the content of those messages because they appear to be deleted from both the defendant's phone and CL's phone.
Does CL's carrier records and call history corroborate CL's testimony?
Yes.
One could argue that, of course, there were calls and texts between the defendant and CL because CL worked for her. But then why delete certain messages?
What on the early morning of Eric Richins' death did the defendant report had happened that evening?
She stated that the last time that she saw Eric alive was between 9:30 and 9:45 p.m. She stated that before going to bed, they had had a drink together to celebrate closing on a house for her business. She said that they got in bed between 9:30 and 9:45, and that shortly after getting into bed, one of the children had a nightmare, and that the defendant got out of bed and went to be with that child in their bedroom and slept in that bedroom until 3 a.m. or around 3 a.m. when she woke. She stated she returned to her own bedroom, got into bed, and felt that Eric was cold to the touch. She stated that she turned the light on, saw that he wasn't breathing and that he didn't look normal, and that she then called 911.
Remember this. It's going to be important later. What woke her up? Approximately 3 a.m. 911 was called at 3:22 a.m. But it is common for witnesses to get times wrong. Remember she said she went to turn on the light? When we get to the timeline of movement recorded by her phone, times and distances are important.
Did the defendant tell investigators when they arrived at her home shortly after she called 911 whether or not she performed CPR on Eric Richins?
Yes, she reported that she did.
What, if anything, did the defendant tell her best friend regarding whether she performed CPR on Eric Richins?
Investigators found text messages between the defendant and her best friend that was her explanation to her friend that she conducted CPR on Eric prior to EMS arrival.
And do those text messages read, "I pumped so damn hard, so hard, screaming at him to come back to life"?
Yes.
What observations did that EMS responder make?
They told me that when they arrived, they began CPR compressions on Eric, and that upon beginning those compressions, Eric began to foam at the mouth. He stated that that observation indicated that CPR was not likely conducted before he arrived.
Well, that's a big deal. Not just because she didn't do CPR, but because of the lies and the nature and quality of the lie to her friend. She made her story dramatic and heart-wrenching.
Detective, as part of your investigation, did you look into whether Eric Richins used illicit drugs?
Yes. Based on the interviews that we conducted with those who knew Eric well, all stated that he did not use illicit drugs other than consuming THC gummies on occasion.
Has the defendant made any statements regarding whether her husband, Eric Richins, used illicit drugs other than THC?
Yes, in several statements made by the defendant throughout the investigation, there have been at least 10 times that she has said that Eric does not use illicit substances and did not use illicit substances.
On the night Eric Richins died, did investigators search the Richins home?
Yes.
Did they find any illicit drugs?
No.
Did they find any paraphernalia or packaging or other evidence of illicit drugs?
No.
Did they find fentanyl anywhere in the home?
Only that which was in Eric's body.
It's going to be difficult to prove this was some sort of accident, if that's where the defense is thinking of going.
What, if anything, did CL tell you about the defendant approaching CL a second time for fentanyl?
CL told us that approximately a week after delivering her first load of fentanyl, the defendant reached out to her again by text or call and said that she wanted some more fentanyl that was stronger than the previous batch.
And does the second Facebook message Was it dated February 25th, 2022 at 9:40 p.m.?
Yes.
Does it read, I need those again, but more, and I don't got a ride, I lost your friend's number?
Correct. CL told us that she again contacted acquaintance 2 and arranged again to meet up at the same Maverick gas station in Draper to purchase again 15 to 30, this time blue round pills that she understood to be fentanyl.
Between, on the way to the Draper Maverick, the second time, when she purchased 15, I'm sorry, did you say 15 to 30?
Yes, 15 to 30 pills.
Which she believed to be fentanyl. Did she make any stops along the way?
Yes, CL told us that the second time that she procured fentanyl for the defendant, she did not have a vehicle to drive on that date. She said that she reached out to a friend, acquaintance 3, and asked that he give her a ride to go purchase fentanyl. She said that he did pick her up, that they traveled from Heber City to the defendant's home in Francis, where, according to CL, the defendant had told her there was a check waiting under the mat at the defendant's home. She said that she checked under the mat and didn't find a check, and so she knocked on the defendant's door, and the defendant came to the door and wrote her a check from her business, from the defendant's business, for $1,300 for the purchase of the fentanyl. CL told us that afterwards they drove to the America First Credit Union in Heber City, where CL banks, and cashed the check and deposited $300 of it into her account at America First Credit Union. She said that after stopping at the bank and getting the cash, they then drove to the Maverick gas station in Draper and purchased the pills from acquaintance 2. Yes, and that warrant returned a copy of the check written from the defendant's business account in the name of CL, and a receipt that shows that it was cashed and that $300 were deposited into CL's account.
Needing stronger fentanyl? That looks bad. The defense could argue that the check was for cleaning work that CL had done for the defendant, and to also distract from the timing of both this purchase and the check, and hope no one clues into the fact that CL needed to use acquaintance 1 to make the first purchase, which shows CL is not a user of this substance, and the fact that CL lost acquaintance 2's number, which shows CL had no plan to continue purchasing this particular item. That the money came from the business account may or may not be meaningful depending on the accounting patterns of the defendant. You'll see in a while how very interesting those accounting practices had become in the months preceding Eric's demise.
Acquaintance 2 in his interview stated that he remembered selling fentanyl to a friend of acquaintance 1's on 2 separate occasions at the same Maverick gas station in Draper. He also said that he remembered the second time that he sold her the pills that CL was with another person who matched the age and gender of acquaintance 3.
Have you interviewed acquaintance 3?
Yes.
What, if anything, does acquaintance 3 say to corroborate CL's testimony?
Acquaintance 3 corroborated all the same details that CL told us about that day, and in fact showed us text messages on his phone that also corroborated that story.
Did those warrants identify what are commonly known as bug-out bags?
Yes. There were several duffel bags stored in the garage, along with backpack-sized day packs, and each was identical and labeled for a different member of the Richins family. Those backpacks were seized subject to a warrant and were inventoried and photographed. Inside the bags, detectives located several items that would be useful in an emergency situation. But the most interesting were documents needed for travel for each member of the family. Each bag contained a photocopy of a state-issued ID in the children's case, along with passports for Eric and the defendant, as well as global entry travel cards for both Eric and the defendant.
Well, it was bad for Eric as well, is that right?
Correct.
It's important to note there was a bag for Eric as well. Some people do this. There's no indication of when or why those bags were packed. This is a good time to bring up the issue of flight risk, which is something that has to be considered at a detention hearing. The defendant has the means and reason to flee.
Kouri made a statement that night to police, a written statement.
Correct.
And she told them that she had made a drink, correct?
Correct.
Okay, so they were aware of that. Was there anything in that body cam or investigation that talks about them looking for a glass that a drink had been made in?
No.
But you said that they searched for illicit drugs, correct?
I don't know if they searched for illicit drugs, but they searched the home.
So they searched the home that night, knowing that he had a drink right before he went to bed, and made no note that they had recovered glass.
She was asking if they'd recovered the drinking glasses. Sorry, I had trouble with the feed. This is a shot at the investigation rather than the fact. I'd wager if the defendant did do this and was willing to admit he'd had a drink, she'd have washed the glasses.
You telling her, well, several times you tell her to think through all of this and let you know that she wants to help. Correct?
Yes, I gave her the opportunity to tell us up front whether she was willing to cooperate or if we should just not bother interviewing her anymore. I don't know if I made that specific statement, but the information that we tried to convey to CL was that we wanted to know the information that she may have regarding Eric's death.
As expected, the defense wants to tear down as much as possible the evidence from CL. What you just heard the detective say is important. The detective asking for what the witness knows about what happened is very different from asking the witness to pin a crime on a particular person.
That third witness never saw CL give those drugs to Kouri, correct? Acquaintance 3 never saw that.
Acquaintance 3 didn't tell us that he ever saw that, no.
The other witness statements corroborating CL's statements are going to be a problem.
And he also states during that interview that at the time of his death, Eric and Kouri's marriage was in a really good place.
Yes.
By itself, that might not mean much. It might mean what it appears. It's not unusual for a spouse to be shocked to learn of an affair or other betrayal when he or she believes everything is good. There's another thing to consider, and that's resolution. When an offender has gone through the progression in his or her mind, when she or he justifies it and finally resolves to take the action, they often appear calmer, happier, nicer, resolved. That's why in threat assessment, we look for any sudden change in behavior, even if that change seems positive. If their marriage was in a good place because they'd worked their way to that point, then that's great. If it was due to a sudden behavior change, that's a red flag.
In those trust documents, the sister was made the trustee, correct?
From what I understand, yes.
And you asked JS specifically, or somewhere along the lines of, if they were doing so well, why would he have not changed that back?
Yes.
And he tells you that it was his way of ensuring that even if they were doing well at the time, if there was a divorce, he would get the last word in it, right?
I remember him using that phrase, getting the last word, yes.
Sounds like maybe he wasn't so confident in the relationship for the long haul, after all. In the next clip, you'll hear mention of a Mexican drug cartel This is in reference to insinuations made about an outfitter Eric and his friend used for a hunting trip. Police already found that this hunting trip was legitimate. The outfitter is a real outfitter. Where have we heard a defendant trying to blame a Mexican drug cartel recently?
He had information or believed that this outfitter was somehow connected to the cartel, correct?
I don't recall. That sounds familiar, but I don't recall if those were the words that he used.
But
JS made a statement about the cartel when he was talking about Eric and that hunt, yes.
Was Detective Woody removed from the case?
She wasn't removed from the case. She could no longer fulfill those duties.
What is she doing now?
She's in patrol.
Traffic.
No, patrol.
Patrol. As in, like a
Responding to emergency calls, yeah. She's also part of the K9 unit.
He's the wrong person to ask about the other detective, and it's a crappy position to put him in. It's not like there's a jury in the room to influence. She does show her hand here, though. The defense also makes hay of the fact that the detective on the stand went to visit Ms. Richins, suggesting he should have known she had legal representation. The prosecution addresses this in the next clip.
Let me turn now to the April 13th, 2023 date when you introduced yourself to Ms. Richins, the defendant. What's the first thing the defendant did when you introduced yourself? About how long did she talk?
3 hours.
She gave any very excited to talk to you and surprised you taking so long to come talk to her?
Yeah, she made multiple statements that she was glad the investigators were there to talk to her because she felt that she hadn't been in contact with the sheriff's office very frequently before that day.
Did it come one or even several times towards the end of the interview when you said your goodbyes, tried to leave, and she continued to talk?
Yes.
Well, either the defendant was glad to see investigators and had nothing to hide, or it's something else. The something else investigators often see is when an offender sucks up to them, either to get information or otherwise try to control the direction of things. The defendant was in sales. Maybe she thought she could sell them. Next, we'll hear about cell phone data on the night of the event. The sound is terrible, so I've posted a text timeline to help.
Was there anything significant that occurred at 3:22 hours on March 4th?
At 3:22, yes, a 911 call was made.
So between the time that the phone is used at 3:07 that morning and 3:22, is there any activity that could be seen from the download?
There is.
What is that?
At 3:07, the device is unlocked. At 3:08 a.m., the device reports some type of movement, either the device itself or a connected device. At 3:12, the phone was unlocked. At 3:16, the phone was unlocked again. At 3:19, the phone was unlocked again, potentially twice. Again at 3:21, and then at 3:22, the 911.
So roughly a time frame of 15 minutes between that phone is used and the time that a 911 call is placed.
Correct.
Now, the attached device that's recording movement, could that be an Apple Watch?
It could be.
Do you have any way of telling from the extraction you examined what that device was that was recording that movement?
So far in the extraction, I have not been able to. I may at some point, but at this point, no.
And as far as the movement, what kind of movement is this? Is it significant?
It is significant, I think, for it occurring in a home.
And can you explain what that movement was?
Correct. So at 3:08, there's movement on the phone, or on a device is connected to that phone is moving. And it moves, I don't remember the exact amount of time, but I believe it's several feet. I do know that some point, there was two movements right before the 911 call, and they're both significant. One was about 240 feet, like 74 meters and change, and the other one was about 130 feet. This is right before the 911 call.
Remember what she said? She went into the child's room and slept. She woke up at approximately 3 a.m. She went back to her room and felt that Eric was cold. She turned on the light. How far away was the light? And called 911. I notice we didn't hear anything here about CPR, but we're not looking at her actual statement, so we'll have to see where she fits that in.
As you were analyzing the forensic data from that extraction, were you able to observe any noticeable patterns of deletion from that phone?
It appears that there is some deletion in that device.
Can you describe what is being deleted?
It looks like there's gaps in things like web history, web searches, particularly the call up. When a person in a call or a text was recorded in the call out of the phone. And there are texts there's messaging that is included in the carrier report. I would expect to see also logged within the device that are not in the device.
On April 18th of 2022, an internet site of an article entitled "What Happens to Deleted Messages." On May 10th of 2022, did that phone access a site for an article entitled "How Do Police and Forensic Analysts Recover Deleted Data from Phones?"
Yes.
Did that phone was a query placed in that phone, quote, "Can cops, period, uncover deleted, period, messages, iPhone," close quote? Yes. Did that phone search, quote, "How to, period, permanently delete information from an iPhone remotely," close quote?
Yes.
Did that phone search, quote, "luxury for the rich in America"? Did that phone search, quote, "If someone is poisoned, what does it go down on the death certificate as," close quote? Yes. Were you able to tell when those things were searched?
The search themselves, there was no date and time reported for the individual search. However, I found corresponding websites to those searches that did have the data history.
And was there a certain time frame that these searches were made? Can you describe that?
Typically shortly after her original phone was seized. So from middle of April of 2022 through, memory serves me right, about August of 2022 off and on.
Delete remotely? This search is from the phone she got after her other phone was seized. Is she looking for a way to remotely delete data from the phone the police had? That's how it looks. This witness also testified to cell phone mapping and communication of CL's phone. It was consistent with CL's story.
Was the mapping that you did CL's phone consistent with gave to law enforcement regarding that first drug purchase?
Yes.
Okay. How did you first get involved in this case?
I was originally contacted by the investigator for the estate of Eric Richins.
Were you able to determine at the end of 2021 how much the defendant was obligated on those debts, those $6 million debts? And actually explain to me the difference. What does obligated on a debt mean?
That's a very important question and a very, very important point to understand here. I don't have access to the documents that tell me the terms of these loans. So I don't know what the interest rate is of these loans. I don't know the terms that she's agreed to for these loans. I don't know what payment is required on these loans. What I do know is these are what we colloquially call hard money lenders, And I do know on some of these what these lenders do require, and it's in the neighborhood of 12 to 15%. These are not conventional loans where there's a 30-year payment amortization. These are typically short-term loans.
So do you have a rough estimate on what she was obligated to at the end of 2021?
Yes.
And what's that?
At the end of 2021, a little over $4 million.
Okay. Debt the defendant was servicing in December of 2021, for instance.
Yes.
How much was that?
The debt payments were about $252,000 in that month. The debt payments that she made in 21, the 4 payments, and those 94 payments totaled $252,000.
Is there anything that you found significant about those debt payments?
Yes.
What was that?
They were not to 94 individual entities. Some of them were weekly payments. For example, I know that she has an outstanding debt during that time of $5,438 that was required to be paid weekly on a debt. She has a $600 payment that is made daily for a period of time during December. Okay. I know of one account that she has that had sued her, and they filed suit in New York in December 9th of 2021. I can say about those payments that several of them did not clear the bank. And
Why was that?
She was in the negative in that account for a good part of that month. She was $22,000 in the hole for a good part of that month.
So you noticed that at least for that account in that month that some of the payments to the hard money lenders were not going through?
That's correct.
Okay. Did you notice any charges for overdraft fees or anything like that?
Yes.
Okay. Well, what did you notice about that?
They were $25 each, and sorry, I don't recall what the cumulative number is for that, but there were dozens.
You said that there was a lawsuit that you were familiar with out of New York.
Yes.
Can you explain what you found out about that?
So that would be a little shy of 4 payments, and then after that she defaulted.
Okay. And when was that lawsuit filed?
December 9th, 2021.
This witness continues to describe numerous debts, payments due, and money moving around. She looked at 11 or 12 bank accounts. The business account was $22,000 in the negative. The defendant leveraged receivables to borrow more money at a 15% interest rate. In the months leading up to Eric's death, business expenses were paid out of their personal joint bank account. Kouri and Eric's personal line of credit was tapped out. Then Kouri started depositing checks from the business, checks she knew couldn't clear, into her and Eric's joint account, then withdrawing the money before the check could bounce. It was all out of control. If she was hiding this from her husband, he was bound to find out, probably sooner than later. In any case, her sandcastles were being walloped by a big tsunami of creditors. And by the way, there's a word for knowingly doing some of these things with the checks. It's called fraud.
Happening in the acquisition of properties and how those move together. And so there's this noteworthy crescendo that happens in the months leading up to Eric's death.
Let me ask you about the life insurance policies. Are you familiar with life insurance policies
Yes.
on Eric's life?
Yes.
How many life insurance policies were there on Eric's life at the time of his death?
I believe there were 6.
Okay. And What were they? Can you explain what the life insurance policies were?
Yes. The first was through Minnesota Life for $347,000, and that was what is typically called a home mortgage policy, in which if the insured passes away, the home's paid off, and they write it at the amount of what the loan balance was at the time the policy's taken out, and so that one was paid. And then there's a life insurance policy that Eric and his business partner had on each other, basically, and that's in coordination with a buy-sell agreement on their business. And so if one of them passes away, the other would be the beneficiary of that life insurance.
What was the amount of money that Eric's life was insured for at the time of his death?
About $1.2 million, aside from the business buy-sell policy.
And are you familiar with any attempt to beneficiary of the business policy?
I'm aware that that is the report, yes.
And what was the report?
That on New Year's Day of 2022, that in New York Life's online portal, someone had logged in and had changed the beneficiaries on that policy.
To
Richins.
Okay. And that was changed back, as far as you know, had been changed back at the time of Eric's death?
That's my understanding, yes.
Okay. Do you know how much money the defendant got in insurance payouts?
$1.3 million, a little bit more than that, $1.3 million in June of 2022.
How much did Eric know about what she'd been up to? He had a stable income. If he'd left her, she'd be ruined. We're going to hear what each side says in closing. As this is a detention hearing, we're watching for some particular major principles to be addressed: ensuring court attendance, protection of the public, and that includes victims and witnesses, and the strength of the prosecution's case.
Since Eric's death, we have learned and unfortunately are continually reminded that Kouri is desperate, greedy, and extremely manipulative. If she gets out on bail, I will be afraid not only for my own life and those of all of my family, but most importantly for the lives of Eric's 3 sons. Our family has already suffered enough. Please do not let Kouri out on bail where she will be a risk to do further harm. Please protect what Eric put his life on the line for, his 3 boys. Thank you.
I don't disagree that CL was buying drugs. I think that's clear. She has a history of being a drug distributor. She was jammed up on 4 first-degree felonies. She had a potential federal case hanging over her, and then when they look at her phone, they find evidence of additional drug distribution. When we look at the cell phone mapping, yes, we know that she went and picked up a check. We know that she was cleaning houses. We know she cashed a check. We know she picked up drugs. But they can't put her anywhere in the same vicinity of Kouri's phone, because apparently the mapping's not available from Verizon, which somewhat surprises me, given it's Verizon.
I think it's a length of time between the event and the request.
Correct. But they have corroborating evidence for all the things about her buying and selling fentanyl. They have 0 corroborating evidence for anything related to Kouri requesting it, her giving it to Kouri. She didn't tell anybody that she was buying it for Kouri. She never had anybody with her when she dropped it off. There's nothing to make the most important correlation in this, and that's that it was ever provided to Kouri, that Kouri ever. There's nothing to corroborate anything she says that ties it to Kouri. The glass, Kouri tells them she made him a drink, right? The glass is there. No one thinks to bother to.
Where's the evidence that the glass is present?
Whoops. Not a good idea to think you can slide such an obvious thing past the judge.
Well, they didn't look for a glass, I guess is what I should say.
Okay.
So no glass was tested. So there's nothing to show that Kouri did anything to Eric. And by Detective O'Driscoll's testimony, it could have been accidental.
Oh no, that is not what he said. The detective said that in such cases it could be accidental, or the S word, apparently I can't say that on YouTube, or homicide, and that the detective had to remain open to all possibilities. It's important for investigators not to be tunnel visioned, and so he's doing what he's supposed to do.
I mean, it very well could have. And I think that, given the evidence presented today, is a very plausible situation. Being bad with money does not make you a murderer. Being bad at managing your accounts, makes you bad at math, but it doesn't make you a murderer.
Makes you bad at math? Are we talking about forgetting to carry a 1? I don't think so. There was no math problem here, but there certainly was a problem of deception, a problem with either self-control or entitlement, a problem of betrayal, a willingness to put your own kids' futures at risk.
The other thing I think that's significant is by the testimony that came out today, the hard money loans that she owed, at least, far exceeded life insurance policy that was paid.
Are you kidding me? Bank robbers will take notice. Hey, Judge, when I robbed that bank, I didn't get as much as I wanted, so just never mind, okay? Like, it means I'm innocent, right?
And so even getting the life insurance money was not going to solve Kouri's problems, not even close to solving her problems. And so that evidence alone, while, maybe there's some other issues with Kouri's business, there's nothing to tie it to her having any motive or in any way being in a better position.
I don't know, man. She got around $1.3 million. That sounds a lot better than the debt she had.
From Eric's death. In fact, she's in a worse position because of his death, because Eric had a business. He was continually making money. He was, from what it sounds like, the one putting the majority of the contributions into the joint account. So his death, from a financial perspective, has harmed her far more than any money that she gained from any life insurance.
Well, that depends, doesn't it? The argument is that $1.3 million isn't enough. Was Eric going to give her a couple of million? If he was going to take care of everything, then why'd she have to run around kiting checks? Or maybe he was about to find out what kind of hole she'd put them in, and maybe that would have been it. He would leave her, and she would be ruined. Those things spell motive.
With that, I'll largely submit on the remainder of our briefing, as I trust the court has been through it all.
I have, carefully. Thank you.
What? That's it? She didn't address anything other than the strength of the prosecution's case. That's the weakest ground. I mean, unless you've got a slam dunk or the prosecution's case is embarrassingly bad. She didn't address public safety, ability to abide by court orders, flight risk. Oh boy.
Ms. Cassell.
Thank you, Your Honor. With respect to the no corroborating evidence, there's a lot of corroborating evidence that corroborates CL's statements. And I think one of the things that we have that's said is, that she was primed and told what to say. But what really happened is she's, a year later she's asked to consider what, if she remembered anything else, and she came back with, I remember more, and that's very typical of witnesses. It's typical of people that we have testify. And then just you heard all of the corroborating evidence, Your Honor, the matching with the cell phone records, matching with the mapping. So we have the evidence that Kouri got, or the defendant got the drugs. We also have the evidence that corroborates all or most of CL's story. We would have more if there weren't texts that were deleted. We have a great deal of information that was deleted, and that was deleted off of the defendant's phone. So I think that is just for CL, and that makes CL credible. This idea that no glass was tested, well, if you look at the pictures that we have submitted, there's nothing there. It's a stage scene. How they can argue that Eric somehow consumed this himself? There's no glass, there's no baggies, or 5 times the lethal dose is not accidental, Your Honor. That is someone who wants Eric dead, and the person who benefited the most from Eric being dead is the defendant, or the person who thought she was going to benefit the most from Eric being dead is the defendant. She thought she was going to be entitled to Eric's estate. She didn't know that there was this trust that had put the money into Kouri Richins' name. So she's the one that thought on the day that Eric died that she was the one that was going to benefit. She benefited from the insurance policies. She thought she was going to benefit from more, and she thought she was going to benefit from Eric's estate. She tried to benefit from the other life insurance policy on Eric's business. That didn't happen. She also was in dire financial straits, Your Honor. Writing checks on closed accounts or checks with no money in them, needed to get out of this debt, and that's the reason she killed Eric, in hopes of getting his estate, in hopes of getting his life insurance policies, and that, Your Honor, we believe is substantial evidence.
In considering this evidence, a jury could reasonably choose to discount and find unpersuasive defendants' efforts to poke holes in the state's case, and in so doing, a reasonable jury could reach a verdict of guilty beyond a reasonable doubt on the charge of aggravated murder based on the state's evidence. For these reasons, the court determines there is substantial evidence to support the capital felony charge of aggravated murder against the defendant in this case. But the circumstances of this case weigh soundly against granting pretrial release of any kind. The severity of the sanctions that follow a conviction for aggravated murder creates a powerful incentive for a defendant to resort to desperate acts that might include harming themselves, harming the members of their family, or harming witnesses in the case. Because an incentive this powerful cannot be adequately managed in the community, it weighs heavily against granting any form of pretrial release. Second, the state has offered substantial evidence that defendant procured fentanyl on more than one occasion, and on at least one occasion deployed that fentanyl to cause the death of another person. As a general matter, an individual who is capable of this kind of decision-making is not a good candidate for supervision in the community. More specifically, given the uniquely dangerous nature of fentanyl, which has been demonstrated tragically by events in Summit County, defendant's alleged conduct, as supported by substantial evidence, is especially dangerous. Indeed, these circumstances constitute clear and convincing evidence that defendant would pose a substantial danger to the community if released on bail, a substantial danger that cannot be adequately managed by any combination of conditions of pretrial release that are available in Summit County. For these reasons, the court finds the circumstances of this case, as supported by substantial evidence, weigh soundly against any form of pretrial release. The state's motion for pretrial detention is granted. Defendant Kouri Richins shall continue to be detained without bail during the time she awaits trial or other resolution of the criminal charges against her.